Hi, my name's Erin Tenner. Welcome to Buy-Sell Basics. I've been representing businesses in buy-sells for 30 years. I've handled hundreds of buy-sell agreements. I'm an attorney and a partner with Duffy LLP. And this is the second in a series of webinars on buy-sell basics. The first webinar was about 3 different kinds of buy-sell agreements. If you missed it, you can view it at our website, www.grayduffylaw.com. The next 3 webinars will be about stock sale and purchase agreements, shareholder agreements, and real property purchase agreements. This webinar is about asset purchase agreements. So let's get started. Most buyers prefer asset purchase agreements over stock purchase agreements because it's a way to avoid assuming the seller's liability. When you buy stock, you're buying all the assets and liabilities. When you buy just assets, you can pick and choose what liabilities you want. But the limited exposure is not automatic. It's the result of a carefully crafted agreement and properly handled transaction from start to finish. And this is where we lawyers come in. It's our job to mitigate risk. So today I'm going to talk about how we do that in the asset purchase process, from negotiation through closing, how an asset purchase agreement is set up, and some of the more important provisions that help to prevent liability. So I sometimes first hear about a buy-sell when I get a phone call asking me to review or draft a non-disclosure agreement. A non-disclosure agreement is just an agreement that a buyer will be asked to sign, or a potential buyer will be asked to sign, agreeing not to talk about or disclose the fact that the seller is thinking of selling, or any of the information that the seller will provide to the buyer for review in deciding whether or not he wants to buy the dealership. Often there's a broker involved when there's a non-disclosure agreement. And make sure, if you're a buyer dealing with a broker, that the broker has the authorization of the seller. I got a call once from a client telling me that a broker was trying to sell his dealership, and he had not authorized him to do that. Why would a broker do that? Because they think that if they can get a buyer lined up, they can then go to the seller, and the seller will agree to pay them a big commission to bring them that buyer. We had to send the guy a cease and desist letter. If you're dealing with a broker who doesn't have authorization from the seller, you're going to waste a lot of time and money. The way you find out if they have authorization is you ask to see a copy of their agreement with the seller, or you ask to talk to the seller directly. If they won't let you do that, it's a big red flag. In other cases, I just get a call from the client who tells me they've already agreed on a purchase price and they need me to draft a purchase agreement. What they're talking about when they say they've agreed on the purchase price is goodwill, the goodwill number, also known as blue sky. The goodwill is the value of the intangible assets of the dealership, such as name recognition or customer relationships. And most of the value of the dealership is in the goodwill, or of any business. Most of the clients I represent are auto dealerships, so I'm going to give a lot of examples about auto dealerships. But I do handle other buy-sells for other types of clients as well, so I'll talk a little bit about that as well. So the easiest way to determine goodwill is by taking a multiple of net income after reserve for taxes. It's kind of a simplistic way to explain how it's determined, but it's usually a smaller multiple for a service business, a larger multiple for a retail business. For example, for a service business, it would typically be 1 to 1.5 times earnings. For auto dealerships, it used to be 2 to 3 times earnings pretty consistently, but when the publicly traded companies came in and started buying up dealerships, the multiples went way up, and now they're anywhere from 3 to 10 times earnings. Even among different types of dealerships, different makes, the multiples can vary greatly. You'll get a much higher multiple for a Mercedes dealership or a BMW dealership than you'll get for a Mazda or Subaru or VW dealership, for example. And even within a single make, the multiple might vary. For example, A Toyota dealership might typically bring a multiple of 6 times earnings for goodwill in California. However, years ago I had a client who was selling his dealership, and he was asking 6 times earnings, and everybody who looked at it said that they were scared to pay that number because it was a really large number when you did the math, because he was a really good operator. He was very profitable. And people looking at it didn't think they could necessarily duplicate his profitability. So they weren't as eager to do that. The economy was a little soft at the time. As soon as the economy started to firm up, he was able to get what he was asking for. Conversely, if an operator is not very good, I've seen Toyota dealerships that, you know, earn $500,000 or less. It's pretty uncommon, but it happens. And it's almost impossible to find a Toyota dealership to buy for under $10 million. So if somebody's looking at a Toyota dealership and it's got very low profitability and they think they can bring it up to, you know, earning a couple $1 million a year, then they might be willing to pay 10, 15, or even 20 times earnings for that dealership because of what they think they can do. There was a time when nobody would pay for a dealership based on anything other than what the current operator was doing at the time, but those times have changed, and now buyers seem to be more willing to pay for things they wouldn't have years ago. So in addition to the goodwill, the fixed assets will also have to be purchased, and fixed assets include furniture, fixtures, and equipment. Sometimes they can include leasehold improvements as well. Inventory will be purchased in any business, and in an auto dealership, the inventory would be new vehicles, used vehicles, and parts and accessories inventory. And work in progress, which would in a dealership be, for example, service work that's in the middle of being completed but not done as of closing. Also, customer contracts and many buy-sells can be a big number. In auto dealerships, they don't end up amounting to a lot because there are often many cars that have been sold and not delivered yet as of closing. There might be 2 or 3. But in some businesses, customer contracts can make up a big part of the value of the business, especially in a service business. Whether a buyer is using or a seller is using a broker or not, the buyer is going to want to see the seller's financial statements, probably for the last 3 years. And financial statements are typically the only thing delivered before a purchase agreement is signed. Some buyers rely on them more heavily than others. Some have their own processes, and they'll just look at the number of cars sold, which you can usually see on a financial statement, and some of the other numbers, but won't rely too heavily on it. They'll run their own process with those numbers to see how much profit they would make. Others will rely heavily on the financial statement. If you're relying on a financial statement, you need to look closely because not everything is going to be stated there. For example, if the dealership is leasing the property at below market rent, it's not going to show up on the financial statement. If the buyer is going to be assuming the lease, the buyer is going to want to look and see if the lease is going to be expiring in a year or less, or if it's a long-term lease. If it's a long-term lease, they're getting the value of that lower fair market value. If it is a short-term lease, they're going to be paying higher rent soon enough, and they may want to calculate the net income using the higher rent value, which would reduce the net income and give a lower number when you multiply it by the multiplier to determine goodwill. I could do a whole webinar on how to value a dealership, even though I'm not a valuation expert, but that is not the point of this webinar, so let's move on. Letters of intent are often used at the beginning of a buy-sell process just to make sure the parties have agreed on, in principle, on what the terms of the agreement are. They're generally not intended to be binding agreements to buy or sell. They can be if they're not written properly, but that is not the point of them. The point is to have a binding obligation to negotiate in good faith on the terms stated in the letter of intent. When a buyer comes to me and tells me they're buying a dealership, one of the first things I do is I have them form a new entity. And the new entity will be the buyer on the purchase agreement. The new entity is funded it sets up a bank account, and then that bank account is funded with the purchase price. That's the way the new entity is capitalized. And then that purchase price that's in the bank account will be, that money in the bank account will be used to pay the purchase price. The whole point of forming the entity is to limit the liability of the owners of the entity so that they have no liability for anything other than what they put in to buy the business. And same with operating the business down the road, as long as the entity is a limited liability entity and it's maintained properly, set up properly, properly capitalized, then the individuals will have no liability. So that's the first step in limiting liability in an asset purchase agreement. Asset purchase agreements are typically set up with several different sections. They have standard provisions at the beginning and the end, which just identify the parties and give kind of a preamble to what's going to be happening. And then at the end, the standard provisions are typically notice provisions and maybe attorney's fees provisions and some other things like that. But the body of the agreement sets forth the assets that are going to be purchased, the purchase price or how it's going to be determined, the real estate, how that's going to be handled, because usually when somebody's buying a business, they're either leasing the real estate or they're buying it. Occasionally they're moving it. It'll have a section on contracts that are going to be assumed, if there are any. In a dealership, usually the only contracts that are assumed are the dealer management systems, if any, or any contract that's not a 30-day or less, terminable on 30 days or less notice contract. Long-term contracts are usually assumed, but there usually aren't many in auto dealerships. And sometimes the buyers want to assume those, and sometimes they don't. There are also warranties and representations. There will be a section for warranties and reps from the seller and warranties and reps from the buyer. And those are just things that each party is telling the other that they can rely upon in going forward with the agreement. An example of a seller's warranty and rep would be that the seller will deliver all of the assets free and clear of liens and encumbrances at the closing. An example of a buyer's warranty and rep, and this would be a seller's rep too, coming from the seller, would be that the buyer has the authority to enter into the agreement and that no other consents are required. Then there is always a section on conditions to obligations, and these are things that would not be in a letter of intent. This is why you need the formal purchase agreement. Conditions to obligations are things like if a lease is going to be signed, the buyer's condition would be that the seller sign the lease at the closing, and the seller's condition would be that the buyer sign the lease at the closing. And it's really important to make sure that these documents that need to be signed at closing are prepared in advance and attached to the purchase agreement when it's signed. Otherwise, you're going to have to be negotiating them once the purchase agreement is signed, and if you don't agree on the terms, then either party can walk away and have no liability because you didn't agree. Covenants are another section which include indemnity agreements, and indemnity agreements are important because these are provisions that say if one party ends up having expense or liability for something that was really the other person's responsibility, then the other person will pay for it. So an example of that would be if the dealership for the seller would say that he's indemnifying the buyer from dealership operations prior to closing. So if they repaired a vehicle and the vehicle was in an accident after closing and somebody sued for negligent repair and they sued both the buyer and the seller, which often happens because usually the buyer takes the seller's name as part of the goodwill, then the seller would be hiring the lawyer and defending the buyer and paying any expenses and fees and damages that arose out of that. So I want to talk a little bit about allocation of the purchase price because this is a real important part of an asset purchase agreement. Oftentimes I see parties want to just lump everything together. They'll say the purchase price for goodwill and fixed assets is X dollars, and the purchase price for inventory shall be determined by the formulas that are typical. That's a bad idea because ordinary income tax is going to be paid on the gain from the sale of fixed assets, as well as sales tax will be charged on fixed assets, whereas goodwill is taxed at capital gains rate. So if you lump it all together, guess who's going to be deciding what the allocation is? It's going to be the IRS or the sales tax agency, and you don't want them deciding how much you're allocating to fixed assets or goodwill. It's real easy to do an allocation to fixed assets. You can either allocate at book value or you can allocate at fair market value and place it in use and have an appraisal done. And they can be very different numbers. It doesn't matter what the number is as long as you can justify it, as long as you've agreed on it, and as long as you've both reported it the same on your tax returns. That's real important too, and the agreement should say that the parties will both report the allocation the same way that it's stated in the purchase agreement on the tax returns. So fixed assets are a big topic, not only for the purpose of allocation, but also for the purpose of making sure an agreement is enforceable. Another important provision is one stating that a list of fixed assets will be attached as an exhibit to the purchase agreement. It's important because the agreement might not be enforceable if the fixed asset list is not attached. Why? Because it's not always easy to tell what's a fixed asset and what isn't. For example, fixed assets typically include furniture, fixtures, and equipment, but they can also include leasehold improvements, as I mentioned. Well, a fixed asset is a fixture or a leasehold improvement, or maybe not if leasehold improvements aren't included. And leasehold improvements often aren't included because they're a big number, and often they're included in the value of the lease or in the value of the real property if it's being purchased. So a fixture is something that's affixed to the ground. A leasehold improvement is something that the tenant brought in for use in the business and added it to the property to use in their business. So safe and reasonable minds can differ over what's a fixture and what's a leasehold improvement. For example, say an above ground hoist. It's affixed to the ground. It's also brought in by the tenant to use in their trade or business. So it could be a fixture, it could be a leasehold improvement. If the buyer isn't purchasing all leasehold improvements and all fixtures and there isn't a list attached, then the parties could get into an argument at closing over hundreds of thousands of dollars worth of assets that are affixed to the ground and could be fixtures or leasehold improvements. And no judge in their right mind is going to enforce an agreement if they can't tell what the parties agreed to buy or sell. So if you want an enforceable agreement, you better make sure you have a fixed asset list attached. Successor liability is a big issue in any buy-sell. And the reason is if you're buying stock, you're going to have successor liability. And that means you're going to be responsible for all of the seller's liabilities, everything. If you're buying assets, you don't want successor liability. And the only way liabilities are going to be avoided is if you take steps to make sure they are, even if you're doing an asset purchase agreement. Like I said, the avoidance of liability is not automatic. Typically, the buyer will have paid more to buy assets than they would have paid to buy stock because they're not taking all the liabilities. And so the last thing you want to do is end up with successor liability. So what are some of the liabilities that are avoided? Unsecured creditor claims are easily avoided in an asset purchase agreement by simply complying with the bulk sales laws for the state. Most states have adopted the bulk sales laws, and sometimes you don't have to do anything to comply. In California, if the transaction's over $5 million, you don't have to do anything to comply, but you still want to say in the purchase agreement that you complied. I get attorneys asking me all the time in buy-sells to agree to waive the bulk sales law. I don't want to do that, because if I get a call from a creditor after closing, I'm representing the buyer, and the creditor or his attorney says my client has successor liability for their unsecured creditor claim, all I have to do is show them that the purchase agreement said they were going to comply, that they complied with bulk sales laws. And typically that claim will go away because that's the whole point of the bulk sales laws, to prevent the buyer from having liability for the seller's unsecured creditor claims. If, on the other hand, I put in the agreement that I waived compliance with the bulk sales laws, I've just given that creditor the ammunition to go after my client and collect from him for the unsecured creditor claim. Secured creditor claims are even easier because there's always a record, a public record of secured creditor claims. If there's no public record, the buyer is not going to be liable for it. A secured creditor claim is just a lien against assets of the business. So in an auto dealership, there's going to be a lien for all of the new vehicle inventory against all of the assets of the business. Also for equipment, if there's equipment that's been leased, there would be a lien filed against that equipment. And a lien is just a representation of a security interest. So the lender would have a security agreement, would file a UCC lien, which gives the world notice that it has a security interest, and then at the closing we go search the public records, we find all those liens, and we make sure they're all released as of closing. Now you can get warranties and reps from the seller that everything will be delivered free and clear, but then if it's not delivered free and clear, if you didn't go do the search and clear all the liens, then you're going to end up spending a lot of money dealing with lawsuits and staving off creditors after the fact, so you don't want to have to do that. Contingent liabilities are things like lawsuits that haven't really come to fruition yet, and you can usually do a litigation search to find those. The seller can represent warrant that there aren't any, but the seller might not even know if one has been filed but not served yet, that it's out there. And usually they're not a problem unless they affect the assets, unless you're buying stock, of course, which I'll talk about in the next webinar. Tax liabilities are a big concern because they can add up to a lot of money. And it's usually not the income tax that's a problem, because most sellers are either S corporations or limited liability companies, and those are pass-through entities. So they don't pay taxes. Their owners pay the tax. So you don't have to worry about the tax unless it's an S corporation that lost its S selection, and then it becomes a C corporation. And if you're buying from a C corporation, if you're buying assets, then you do need to worry about income tax. But you always need to worry about sales tax, employment tax, and franchise tax, because those liabilities in California, and I'm sure in other states as well, will attach to the buyer. Even if the buyer doesn't know anything about them, even if there's no record of them. You can do a tax lien search, but it might not show everything. So how do you protect the buyer? The buyer will get tax clearance certificates, if possible, prior to closing, and they can usually be gotten for employment taxes and franchise taxes. Sales tax are a little trickier. Usually can't get them before closing, so we hold back money in escrow. We estimate what we think the tax will be. We might double it or add another 50% of that amount in case there are penalties, in case there's an audit after, in case there are, is interest owed. And that money is held back in escrow until that tax clearance certificate can be obtained, and usually can be obtained within 2 or 3 months after closing. And then you authorize escrow to pay from that holdback any taxes that are owed if necessary to get that tax clearance certificate. Factory liability should never be a buyer problem, but sometimes it is. I was at a closing once, and the factory put in front of my client a document that said my client was going to assume all of the seller's parts account liability, and I told him not to sign it because I've never seen that in 30 years, and we ended up having to negotiate around that. So that can happen. Environmental liability, I'll talk more about that in the next webinar, but it's also something that could be a potential problem for a buyer if they don't know about it, and so you want to do a phase 1. Customer liability, of course, you want to make sure customers are taken care of after closing. So you want to make sure the seller has to reimburse you for anything that you have to pay out as a buyer to take care of a customer if it should have been the seller's responsibility. Employee liability and pension liability are a huge issue. I'll talk more about this in the next webinar as well, but I want to touch on them a little more here because they are often a problem. The purchase agreement will always say that all employees will be terminated as of closing, and that the buyer doesn't have to hire employees, but may hire those it wishes to employ. And it will say that the seller is going to be responsible for all employee obligations and not the buyer. However, if the buyer agrees to even assume one employee obligation, it could step into successor liability for all of them. I'm talking about wage and hour claims, medical benefits, discrimination claims, wrongful termination claims, pension liability, to name just a few. There's a lot of potential liability there. I was at a closing once and I overheard a client telling the seller that he was going to just assume all of the vacation pay for all the employees he was hiring. And that is not what the purchase agreement said. So I told him, no, we don't want to do that, because you could potentially end up with all of the liability. So you got to make sure that you're following the terms of the purchase agreement. There's a reason it's worded the way it is. So instead, all he really had to do, because he really wanted to give the employees the benefit of their vacation that they had accrued, is have the seller pay the vacation pay at closing and negotiate with each employee just like you would any other employee. If they have a vacation coming up and they want to take it, let them take it. Just don't pay them for it. They already got paid by the seller. So there are ways to deal with those issues. And you can rely on warranties and reps for a lot of these things, but sometimes people hide their assets. I've heard of people giving them to their spouse. The situation where I heard about that, the spouse ran off with the assets, which can happen. I've heard about people putting them in diamonds under the mattress, you know. So the warranties and reps and indemnity obligations are only as good as the person making them. You may be better off with a holdback for things that you know about. Once the agreement is signed and in escrow, an announcement will be made to all the employees of the sale. Factory approval will be obtained. Due diligence, some of which I've already talked about, will be done. And I'll talk more about that in the next webinar. Employees will be interviewed by the buyer just like they were interviewing any other employee. And sellers shouldn't be giving away private information about employees either without employee consent. I mean, this is something I see sellers doing all the time, and they shouldn't be doing it. There's no exception in the privacy laws for buy-sell. You should be treating those that buyer just like anybody else calling for a job reference on a prospective employee they're hiring. And then you resolve any issues that come up during that escrow period, and they're always resolvable. At closing, everybody comes together, new vehicles are inventoried, parts and accessories are inventoried, documents are signed, there's always a bill of sale, an assignment and assumption of contracts, it's going to be a lease or a purchase agreement, it might be closing simultaneously, and there'll be a deed to transfer the land, corporate resolutions, factory documents, all kinds of things. This is just a few of them I've listed. Liens are released if they haven't been already on assets, and sometimes money will have to be paid out of escrow, or there'll have to be an agreement in escrow to pay off those liens in order to get the releases. And then the purchase price is determined, and that's a big job for the buyer and the seller. They have to sit down and, looking at the purchase agreement, go through and determine what the purchase price is based on the formula set out in the purchase agreement for each car. And for the inventory, usually there's an inventory service that comes in and does the parts inventory. But for cars, the flooring lenders are going to count the cars, but the parties have to have somebody there to actually calculate the purchase price, and that's a big job. So often they forget about it. So in summary, the point of an asset purchase agreement is to avoid liability. The process usually starts with negotiation of the goodwill. A limited liability entity is formed by the buyer, then an asset purchase agreement is drafted and signed. The agreement, if it's done right, describes the assets in enough detail so a judge could tell what the parties agreed to buy and sell. If it has an up-to-date fixed asset list, that's great. If it doesn't, it's a problem. Any documents that are going to be signed at closing should typically be drafted and attached as exhibits to the agreement when it's signed. Purchase price is going to be allocated in the purchase agreement, and then another document will be signed at closing, which gets filed with the IRS, which is a tax document for allocation of the purchase price. The agreement includes warranties and representations, conditions to the obligations of the parties, and indemnity provisions. And some of the most important provisions are those that limit the buyer's exposure to the seller's obligations, but they're only valuable if the parties follow the terms of the purchase agreement. These include provisions that protect the buyer from creditor claims, the right to hold back money in escrow for unresolved issues, the due diligence provisions that allow the buyer to conduct inspections. And those due diligence provisions don't have to be written in such a way that the buyer has an absolute right to walk. I see people expecting that all the time, and I would never write them that way. The buyer should have to be able to justify its reason for wanting out of the agreement. Otherwise, it's not a binding agreement. An escrow is opened, assuming an escrow is used, and between the signing and closing, due diligence is performed, employees are interviewed one at a time, and their terms of employment are negotiated. At closing, the seller terminates all the employees, the buyer hires those it wants to hire, inventories are completed, the final purchase price is determined using the formulas in the purchase agreement, and closing documents are signed. The parties need to understand and abide by the terms of the purchase agreement. I can't stress it enough. It's so important. Avoiding successor liability is the point of an asset purchase agreement. It'll cost both parties a lot more if they don't have an experienced attorney helping them or they don't abide by the terms of the purchase agreement. Thank you for joining our webinar. I hope you found it the information useful. And if you have any questions or comments, you can email me at etenner@grayduffylaw.com. I hope we'll see you at the next one.